court, gentlemen of the trial table, and ladies and gentlemen of the jury. We came here on Monday of this week for you to have the ability to consider the evidence as it would relate to an indictment returned by the Lorain County Grand Jury, which indicates that they do find and present that the above-named defendant in the county of Lorain unlawfully or on or about November 1st, 2002 through December 31st, 2003, with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a felony crime of a certain degree, did communicate false information to any person in violation of Revised Code Section 2921.32, subparagraph A, subparagraph 5. The issue then becomes, as of the 13th of November 2002, in relation to the charge in the indictment, what did Mr. Miller know, when did he know it, and what information did he subsequently communicate to members of the Lorain Police Department? The evidence has been that this contract began in effect on the 29th of November 2002. There comes a time after that contract went into effect, after the work was done, that rumors spread through the city that perhaps something is amiss. Perhaps somebody has made money, some city employee has made some money, some city equipment was not used. He receives a phone call from Greg Miller, the Safety Service Director, inquiring as to why are you investigating? Eventually there comes a conversation between Lieutenant Foley and Mr. Miller, wherein Mr. Miller indicates to him he's already cleared this with the Ethics Commission, so everything is hunky-dory. Everything is all right. There's no harm, no foul here. Now, that's what he tells Foley. And that's what he tells him on the 22nd of September 2003. And his purpose for communicating that false information is pretty simple. Here the city has wasted $30,000 because it could have used its own equipment. It's personally embarrassing for Mr. Miller, and it's also a problem because he's running for election for auditor. So if we stop it now, if we stop it in September of 2003, again, there's no harm, no foul, no bad stuff, and it'll go away. That false information did not stop Lieutenant Foley, because the very next day he called the Ethics Commission to find out what their position actually was with respect to this. And of course, as you heard from Mr. Roski, the Ethics Commission does not render opinions on things that have already occurred. Based upon the evidence that you have heard here, the evidence indicates in the state's view that once again, Mr. Miller knew about the contract, knew about the leasing of equipment, knew that Doug Johnson was involved, a city employee, and he knew that as of the 13th of November 2002, when he replied, yeah, that's great, in relation to this contract. Again, that contract was not performed until the beginning of, or the end of November 2002, and the investigation began in June of 2003, such that when Miller talked to Foley, he told him that the Ethics Commission had approved this, it was all okay, so therefore there should be no further investigation. Such that the evidence has demonstrated that with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a felony, if this was all approved before anything happened, if this was all approved by the Ethics Commission as he falsely told the police,